information technology and its advancements all over the world, including India, posed a number of challenges to the legal regime, to the investigatory regime, and to a number of other professionals, those who are involved in the law and policy framework in India. So, a number of initiatives have been taken, and there was a large demand for the legislation in India, and it was felt from 1996 onwards. And the legislation was passed in Information Technology Act legislation was passed in May 2000 and came into force from October 2000. This legislation for the first time provided legal recognition to e-commerce, e-governance, and to create an alternative to the traditional methods of paper governance. These were the primary objectives in passing of this legislation in 2000. And the legislation, the Information Technology Act also for the first time defined what are electronic crimes or cyber crimes, what is the punishment, and also has specified the investigatory powers, procedures and mechanisms, and the regulatory framework. The Government of India felt the need to review this legislation, and recently they have set up a committee with the chairmanship of the Brijesh Mishra, and the amendments to this Information Technology Act also are in the process of the getting a legal recognition. In fact, we are glad today to have Dr. T.K. Vishwanathan, Union Law Secretary, who drafted the Information Technology Act and also the proposed amendments. Dr. Vishwanathan is well known as a distinguished lawyer and an academic, and Dr. Vishwanathan is an eminent legal scholar who is well versed in the jurisprudence, international law, and cyber law. He is also as an expert in the legislative drafting, and Dr. Vishwanathan has been working with the law ministry over 2 decades. I also have my colleague, Mr. Anand Gupta, who is helping and assisting in the course 2 of the postgraduate certificate in cyber law. So with these few introductions and introducing the topic, Information Technology Act and beyond, let us have the initial comments from Anand, and then we will move over to our main panelist, Dr. Vishwanath.
As our learner knows, the PG certificate course on cyber law consists of 4 courses. Present lecture is related to course 2. Course 2 deal with the regulatory part of the cyberspace. The name of the course, as you all know, is the regulation of cyberspace. In block 1, we deal with the Information Technology Act, the guidelines issued by various ministries in the cyber area, and international treaties and conventions, etc. Block 2 of the course deals with the cyber crimes, cyber torts, the issues involved in the investigation of the cyber offenses such as cyber forensics, etc. Cyber crimes mainly can be categorized into 2 parts. In one category, we can put those crimes which were in existence before the coming into force of the Information Technology Act. The use of the information technology, especially the internet has added new dimension to these offenses. For example, defamation, forgery, etc. Cyber technology, information communication technology, to be more precise, has added new dimension to these offenses. The other category of offenses are those which, in which we can put those offenses which are specifically related to computers. The offenses which were hitherto unknown to the legal system. With the advancement in information and communication technology, these offenses came into picture. To quote a few examples, cyber, hacking, denial of service, etc. So block 2 deals with these kinds of offenses. Block 3 deals with the regular online dispute resolution. What kind of disputes can be or are being settled through online medium, online dispute resolution, the various issues involved with it. Now I request our main panelist, Dr. T.K. Vishwanathan, to deliver a lecture on the Information Technology Act 2000 and beyond.
Thank you, Professor Rao and Mr. Anand Gupta. This Information Technology Act 2000 is a culmination of a long series of activity which took behind the scenes, and I will briefly start with the circumstances which led to the enactment of this legislation. Now, there is always a controversy between the role of law in a changing society, because there is always social changes take place, and law has to keep pace with the social changes. The role of law vis-a-vis the social changes is always a subject of debate. I may briefly quote from what Wolfgang Friedman opens his book on law in a changing society. He says a controversy between those who believe law should essentially follow and not lead, and those who believe law should be a determined agent in the creation of new social norms is one of the recurring themes in the history of legal thought. Now, Friedman was right, because this dialectics between law and social change is as old as history of mankind itself. The third millennium resurrects this age-old controversy with a sharper focus on relationship between law and technology. Law and technology always enjoyed a very uneasy relationship. It was uneasy because technology is always ahead of law, and law is forever lagging behind, meeting the challenges posed by technology. New technologies always create problems for law enforcers and policymakers, but then till now, lawyers and the policymakers were able to deal with these changes without much breakdown of legal resources. The history of mankind has seen many revolutions. All revolutions were attended with bloodshed, but digital revolution, which has ushered in this cyberspace and a knowledge economy, can be said to be the mother of all revolutions. It can be said to be a mother of all revolutions because digital revolution has ushered in an age of digital discovery and digital